Entry 6 says public health. Entry 8 says intoxicating liquor. Why can't the state say that, well, we are concerned about the fact that there are products in the nature of denatured spirit which are being passed off as intoxicating liquor, and we want to prevent that happening by having regulatory measures in place. Limited to that purpose. One way of interpreting it.
Entry 6, my lord, entry 6, even law and order. Even law and order. The reason I'll tell you a lot.
Once we accept that the states can do it, whether it's under entry 6 or entry 8, it makes no difference.
No, I am protecting 52.
Incidental.
Share your lordship's concern that so far as the effect of an abuse is concerned, the state would be more concerned in regulating that. Lord, kindly examine, my lord, from another angle. What would be the constitutional position, my lord, if that view is taken? That's my respectful submission. My lord, one thing is clear, if I am right, that non-potable liquor, the regulation is with the center. Potable liquor, regulation is with the state. That's the constitutional position. Now, your lordships, by a judicial verdict, create a third category, that any abuse of non-potable liquor as potable liquor will go to the state, which would amount to amending the entry.
Take a case of, say, the state of Gujarat or the state of Bihar.
Yes.
They have imposed prohibition. They have a policy of prohibition.
Yes.
No liquor consumption, no consumption of liquor or alcohol for potable purposes.
Yes.
That is completely, therefore, outlawed within the state. If we accept your very rigid classification, that would mean that much as though these two states have imposed a policy of prohibition, you cannot control the inflow of this clandestine trade in, say, denatured spirit or industrial alcohol, which is capable of being and is being used for the purposes of...
that is not a practical way of looking at it. But not kindly see, where do we stop? If that is so, the state can, if that is right, then the state can legitimately say that non-potable alcohol which is manufactured in Gujarat or Bihar, also we will control that it has to have a particular degree of alcohol so that it is not abused. Then they start regulating the manufacture also. How do we define the abuse? Because maybe at some percentage of alcohol, of the denatured alcohol, it is either easily possible to abuse or it is difficult to abuse. Then, my lord, they can say that for the purpose of ensuring that my prohibition law is not flouted by clandestine means, I will issue a direction to the breweries that this is how you will exercise the power, exercise the manufacturing process of bringing denatured alcohol. Lord, therefore, Lord, even for the purpose of, my lord, a very right concern expressed by your lordships, the solution is a directive by the center under the IDRA that this is how you will have to control. Because this is not a problem, my lord, only in the prohibited state. I mean, states having prohibition.
Everywhere.
This is everywhere because of financial reasons.
Except in the prohibition states, the stakes are much higher because you can't get it lawfully.
Yes, yes. Lord, there are.
So the more stricter the regulation, the more the people want to evade, right? That's why in the prohibition states there's a premium for people who want to evade. And they extract that premium. It's a hard fact.
There are certain things, my lord, for example, even where there is no prohibition. Now people are fed up. We have studied something. With the regular kick which the alcohol gives. For some states, I can't name the states, it doesn't look good. People consume, my lord, very regularly 1 or 2 bottles of cough syrup. Because that's they say it's a different kind of a kick. Your lordships would be amazed. Iodex, which is used, my lord, for the purpose of some pain, etc. Iodex. They not only smell, they put it on a jam like put it on a bread like jam, and they eat.
In fact, usually these NDPS bail applications is a recovery of 3,000 bottles of cough syrup. 14. 3,000 bottles of cough syrup.
Lord, for example, white ink, the eraser ink. So eraser ink, Lord, is a product, Lord, where we used to use it, Lord, when you used to have a manual typewriter. That is being used for intoxication, Lord. Then, Lord, though eraser ink may not be within the state subject, which have you to ensure that it is not misused, the state can, Lord, on that very logic regulate even eraser ink. That white ink, Lord, all of us, Lord, have used it before. These people may not have known.
Erasex.
Yes.
That product is called that
Yes.
whitener.
Whitener, that's the correct one. Whitener.
Yeah, those ballpoints also where you just press it and then it comes out.
Yes, but that was also.
Earlier you guys had those brushes.
Yes.
Small brushes. That's right.
See, that is not an intoxicating liquor at any rate. It is an industrial product.
No, I am saying something else. Say, for example, hypothetically, this whitener or white ink is controlled otherwise by the center under some entry, but with a view to avoid its abuse, it can be controlled by the state also if this argument is, if this interpretation is right.
Under entry 6 of list 2, health purpose.
No, I am saying under 52 they cannot do it. But if there is any other power, of course, my lord, nobody can take away except, my lord, by respectful submission is your lordships would go by the generic sense of the word rather than abuse, my lord. If we go by each entry, its abuse may find place, my lord, in some other entry as well, in some other list as well. And, Lord, I will show when I come to the scheme, my learned friends have already shown 18G of the IDRA. There are power to issue directions that you do this, you do that, etc., etc. And, Lord, maybe regulations can be framed for that purpose. That's the answer. Conferring power and placing it under entry 8 may perhaps not be the correct position. Lord, now kindly come to page 36. Lord, we have borrowed this expression from British legislations.
My only submission is my friend arguing that synthetics is wrong?
Entry 8.
Synthetics says the power is there to regulate industrial alcohol.
But we are on the I'll respond, my lord.
Paragraph
36, my lord, page 36. There is a chart, my lord. Lord, we have borrowed some of the expressions from the British legislations. How British used to, because this has come from 1919 and 1935, at least during the British regime. So we can safely rely upon what they used to consider intoxicating liquor. And I'll show, my lord, the statement of objects and reasons of this act, the Licensing Act.
Before we read this, your submission is that intoxicating liquor means something which can be consumed
As it is as a beverage.
by a human being. And if there is an abuse, there are other powers, other entities which can take care of that. That's what some
Cannot be, in my submission, cannot be traced to entry 8.
There are other entities
Because it is
can-
potable alcohol and UK Parliament enacted the Licensing Act
Many of these acts which you have brought into the chart are also those covered in Balsara. Are they some of these also? Because we'll have to deal with Balsara. You'll have to answer Balsara. Many of these I think are in Balsara also, right?
No. Balsara has not analyzed these acts.
It has not analyzed.
It has not analyzed.
I thought some of these are also the ones which Balsara.
But Balsara mentions this, but they have no, Balsara doesn't analyze it. And I would wish to
So
show.
they find mention in the judgment. They
Yes,
find
yes,
mention
yes,
in it.
yes.
That's what I was asking.
Yes. But please, Lord, see page 36, intoxicating liquor, and I request your lordships to read, which is not, Lord, taken note of by Balsara. The definition of intoxicating liquor means spirits, wine, beer, porter, cider, perry, and sweets, and any fermented, distilled, or spirituous liquor which cannot, according to any law for the time being in force, be legally sold without a license from the Commissioner of Inland Revenue. Now, please come to, my lord, page 578, volume 4B. preamble of this act. Look, this is not taken note of by Balsara. The Lordship gets volume 4B, page 578. An act for regulating the sale of intoxicating liquors. Look, the same expression we have borrowed. Please see. Where does your Lordship get my Lord Justice? Whereas it is expedient to amend the law for the sale by retail of intoxicating liquors and the regulation of public houses and other places in which intoxicating liquors are sold, and to make, I'm sorry, page 578.
Yes, I got it. Yes. Yes, what are you reading?
I'm reading the preamble of an act for regulating sale of intoxicating liquor. It is Licensing Act 1872. So intoxicating liquor is the expression, my lord, we have used in our constitution. No, volume 4B. My lord Justice, my lord.
No, it says it is not applicable to Scotland.
Maybe, my lord, I'm told there are separate acts, my lord.
No, most of the scotches are from
Scotch is made, yes, my lord. The Scotch is made in Scotland. Whereas it is expedient to amend the law for the sale by retail of intoxicating liquors and the regulation of public houses and other places in which intoxicating liquors are sold, and to make further provision in respect of the grant of new licenses for the sale of intoxicating liquor and better prevention of drunkenness. A human being is necessary. And intoxicating liquor. Please see section 3. No person shall sell or expose for sale by retail any intoxicating liquor without being duly licensed to sell the same, or at any place where he is not authorized by his license to sell the same. Any person selling or exposing for sale by retail any intoxicating liquor which he is not licensed to sell, etc., etc. Please see about section 5 also at page 579. Your Lordship gets one at the foot of page 579.
Yes.
The marginal note is seller liable for drinking on premises contrary to license. If any purchaser of any intoxicating liquor from a person who is not licensed to sell the same be drunk, the human element of my lord getting intoxicated on the premises, drink such liquor on the premises where the same is sold, or any other highway adjoining or near such premises, the seller or such liquor shall, if it appears that such drinking was with the privity or consent, etc., etc. But similarly, see, 6. Drunkenness is the subject matter. This is the regulation which the state can make. 6. If any person having a license to sell intoxicating liquor not to be drunk on the premises himself takes or carries or employs or suffers any other person to take or carry any intoxicating liquor out of or from the premises of such licensed person for the purpose of being sold on his account, so and so, so and so, so and so, kindly see last 3 lines. The purchaser thereof on the premises of such licensed person with his privity and consent, and such licensed person shall be punished accordingly in manner provided by this act. This is the regulation which the state can make. Similarly, 8. Every person shall sell all intoxicating liquor which is sold by retail and not in cask or bottle and is not sold in a quantity less than half a pint, etc., etc. This can be, my lord, then offences and penalties at 582. My lord, I am not. And thereafter answered it, my lord. I can answer, my lord, after this long weekend. After expressions are, my lord, the same. Your lordship gets, my lord, the Chief Justice gets.
Yes.
Mr. Herbert.
This is pertaining to intoxicating liquor and drugs in India, although the
Yes,
debate is in
British India. Yes. I beg to ask the Secretary of State for India whether he is aware of the number of shops open for the sale of intoxicating liquor and drugs in India rose from so-and-so to so-and-so, that the net revenue on liquor and drugs consumed in India for the year so-and-so, an increase of so-and-so, so-and-so, and last, shops opened and consequent increase in consumption. The Secretary of State for India, Mr. Bodrick, answers, the increase in the number of shops was considerable only in the two provinces of Bengal and central provinces. In Bengal, it was chiefly due to the fact that many shops sanctioned but unlet in 1902 were let in 2003, and in the central provinces to the government taking over the excise arrangements in certain semi-feudatory areas and to the consequent more strict enforcement of the law. As the increase of revenue in 1982 to 3 over 1901 to 2 in these two provinces was not marked, the additional shops could not have had much effect on consumption. But they also use it in the sense of consumption in shops. But how we regulate? How would the state regulate potable liquor? They will give license that only licensed person can sell. The licensed person will have this much capacity. The licensed person will have to make certain arrangement for securities. The licensed person will have to ensure that it is not sold or consumed in public places. That is the regulation contemplated in the entry 8. If somebody abuses it, that is not within the domain of the state. So similar, I am not duplicating 634. It further goes, hours of sale of intoxicating liquors, page 634. Herbert Roberts asked the Under Secretary of State of India whether he is aware that Government of India have expressed an opinion in favor of curtailing the hours of sale of intoxicating liquors. Sale of intoxicating liquors as beverages. That is how it has always been understood. Whether he has seen the statement, etc., etc. I am not duplicating. But please see the answer. The next, Herbert Roberts asked the Under Secretary for India whether he is aware of the almost unanimous consensus of opinion amongst district officers in Bombay that the change from the unrestricted auctioning of license has resulted in a noticeable improvement in the management of liquor traffic. Whether since the introduction of the fixed fee system in Bombay, there has been a substantial diminution of the consumption of intoxicating liquor, etc. But intoxicating liquor has, this only to show, intoxicating liquor has always been understood as meaning something which is sold as a beverage, which has an impact on impact of intoxication on human beings under licensed premises or under a valid license. And when we say human consumption, we necessarily say human legitimate consumption. Last act at page 37, I am not reading it. Intoxicating liquor sale to persons under 18 Bill 1923.
Page 630.
37. There are two acts, my lord. I'm sorry, one act which remains. Last, my lord, in the chart. Intoxicating liquor within brackets sale to persons under 18 Bill 1923. Lord, your lordships can just note page 636 of the same volume, but it is using the expression in the same term. So my respectful submission is, your lordships would consider using this, giving interpretation to this expression the way it has always been understood. Lord, for example, snake bite is the latest form of kick in some cases. Now, suppose it is capable of being converted into a drink. It would be intoxicating. It may have some amount of liquor, we do not know. So would it be treated as an intoxicating liquor? The answer is no. It is alcohol-based drink which is served as a beverage for human beings, having the effect of intoxication, which is popularly consumed. Now, my lord, I would wish, my lord, your lordships to have what is alcohol and its forms, my lord. So that is at page. I'll come to Balsara a little later when I take judgments, my lord. All the judgments I'll take simultaneously, and then I'll show the scheme of IDRA, my lord. Page 50, if your lordships can see, my lord. This is, my lord, sitting with the officials, my lord, we have prepared this, that what is the type of alcohol? Your lordships were taken through them, my lord. There is some deviation. Your lordships would like me to skip this one.
Well, you are on discussing something else.
Please.
Well, which para?
My lord, I am on page 51, para 60.
The same volume.
Same written submissions, my lord. Lord, I am on para. It is judicially recognized by this honorable court in the judgment of VAM Organics. Lord, I'll just read this para. Before proceeding further, it will be proper to understand the difference between industrial alcohol, denatured spirit, and potable liquor. Ethyl alcohol is a rectified spirit of 95% weight per volume in strength. Rectified spirit is highly toxic and unfit for human consumption. However, rectified spirit diluted with water is country liquor. Rectified spirit, as it is, can be used for manufacture of various other products like chemicals, etc. Rectified spirit produced for industrial use is required by a notification issued under the Act to be demonstrated in order to prevent the spirit from being directed to human consumption. Rectified spirit is denatured by adding denaturants which make the spirit unpalatable and nauseating. As such, rectified spirit can be converted to potable liquor, but once denatured, it can be used only as an industrial alcohol. The process of denaturation described by the respondent is narrated by the High Court in the following terms. My lord, I can skip that. Eventually, my lord, it says,
Telling us just a while back, the switchover from potable alcohol to industrial alcohol, sanitizers and the industrial oxygen to medical oxygen, all that power or exercise under this 1951 Act.
yes. And suppose, my lord, even for non-potable alcohol, which is a scheduled product, scheduled industry, the central government can make a conscious choice that we will not regulate. We will regulate by forbearing to regulate. Let the market forces play its role. We will watch the market forces, and if everything is going on which is in national interest, maximum productivity, equitable distribution, etc., we will not step in. But we have the power to step in. So that is regulation by forbearance. So there is no notified order, meaning thereby we are regulating by exercising the regime of forbearance. And that's the new concept, my lord, in all regulatory bodies, that you retain the power and choose not to regulate. But that is also a choice. That is also a power of regulation.
So you are saying, irrespective of whether there is a notified order or not under 18G, I have the power to issue a notified order, and therefore the states are outstripped by my creating that opportunity for myself.
The reason is, I will develop it, my lord. Since it fell from your lordships, this is a draconian, my lord. I just wanted to say that we are in a regime of forbearance. But I'll develop that. And it may sound a little, my lord, ambitious argument on this. But, my lord, world over, regulators are exercising regulatory powers, power of regulation by forbearance.
But Mr. Solicitor, not this kind of regulation. Regulators are exercising different kinds of regulatory powers, not like
Your
this.
lordships are,
Every time you want to set up an undertaking, you will license it, new product license.
your lordships are not examining Article 14. This is not 19(1)(g) or 14.
This whole statute is an anachronism in today's age. It's a complete anachronism.
Lord, your lordships are, my lord, I am with respect, my lord, repeating, right now the only thing which your lordships would see is whether by a good law or a bad law, the field by central legislature is occupied or not. Whether that law is valid or not is not the question.
The law itself, that is section 18G says, if you want to regulate, you have to issue a notified order.
Lord, there are 4 or 5.
Notified order, you can regulate.
There are 4 or 5 places where notified orders.
No, where is the regulation?
Look at the kind of products it covers. Cutlery, calculating
Nothing
machines,
your lordships are, my lord.
vacuum cleaners, sewing machines.
Lord, I'll show, my lord, that there are only 4 industries which are under regulation. Others are forbearance regime. That's the economic policy of the country, my lord. But your lordships are again, my lord, examining the validity from 14 and 19(1)(g) point of view.
Economic policy, therefore, demonstrating that we are moving increasingly to market-driven economy.
Market-driven economy.
Market-driven economy, you attract investment, you want to
Correct,
create a
Lord.
business-friendly climate, and therefore there is forbearance from enforcing this,
Lord,
except in regard to 4 industries.
I'm sorry, my lord.
But therefore, we can't say that then there is the doctrine of occupied field. It's a conscious decision not to implement the provisions of this act.
Yes, my lord. But I'll show that. I will show that, my lord. Right now, my lord, again, your lordships are persuaded, your lordships have persuaded yourself, my lord, to go into Article 14 and 19(1)(g) arguments, which not, my lord, right now my purpose. My purpose is good, bad or indifferent. There is a provision which occupies the field, and we have chosen not to implement that so far. Maybe, my lord, suppose, my lord, there is a defense industry. Defense industry is one of the exceptions in Article 24, list 2, because of.
So, which are the 4 industries in relation to which the act is now
I'll show,
actually
I'll show
enforced by the government?
I'll show that. Well, let me complete the scheme of that.
It's about 5 to 4. We have to go for Justice Bose's
I know.
the farewell.
Can I start, my lord, on the next?
We were on. We had come up to section 11A.
11. But, my lord, please do not examine it from the point of view of constitutionality.
And Mr. Solicitor, now how much time will you take?
My lord, your lordships would, my lord, agree that I have never repeated anything.
No, not at all. Just
And-
no, absolutely. We are not trying to tell you that you have, but
Lord, I think, my lord, 1 session and 1 hour, my lord.
if Mr. Solicitor, if you can wrap it up in one session,
Lord, the difficulty.
so we can give 1 hour to the people who are following you. After you, who's going to argue?
I'll definitely, my lord, make an attempt, but your lordships would, my lord, not mind my saying this. Lord, Tikaramji doesn't consider any of these.
That point will make, absolutely you've made. No, we are not saying that, you are...
In one brush, one line, it says that it's only for manufacture.
Mr. Solicitor, we are not rushing you at all. Just, if
No, I'll my lord, try to be as precise.
you can wrap it up by the first session on Tuesday, then, the others can wrap it up, say, by 3 o'clock.
Wednesday, my lord, possibly Tuesday, your lordships knows, my lord, maybe a miscellaneous day, my lord.
No, Tuesday is, no.
No.
Wednesday is a holiday. Wednesday is a holiday. So we have Tuesday and Thursday.
But I have no difficulty, my lord. I thought because Monday is a holiday.
It's not a holiday.
Monday is not a holiday.
Not possible.
You are thinking about the long weekend, taking the Monday into account
Yes.
for educating.
Well, that's so far. That the school is closed, that I get the same thrill.
But you wanted to educate yourself on certain passages.
Yeah.
You have to
become
You have to be in some good company over the weekend. Mr. Pallav.
Yes, madam. Yes.
If you can't look
Yes, sir. It has.
if for reasons of professional ethics, you can't look to your right, you can look to your left.
Yes, sir.
So Tuesday we'll come.
Tuesday. Obliged to launch.
16, there are two directions, some constitution benches for directions, but it won't take more than 5 minutes each.
The 902, madam.
Light motor vehicles and that arbitration.
Obliged to launch.